I'm Ben Meiselas from the MeidasTouch network. The identities of the three secret individuals who posted an unsecured $500,000 bond to bail out George Santos when he was criminally indicted by the Department of Justice at the Eastern District of New York Federal Courthouse. Their identities may soon be released. A magistrate judge presiding over the case from the federal court in the Eastern District of New York just issued the following scheduling order after a number of media companies filed a motion to release all of the information about these individuals whose identities have been kept secret, who posted this $500,000 unsecured bond by George Santos. Let's take a look at the scheduling order issued by the court. Scheduling order as to George Anthony DeVolder Santos regarding the motion to unseal documents filed by the various media companies. It says, the government, Department of Justice, and the defendant, George Santos, are directed to respond to the pending motions to unseal by June 2nd, 2023, so ordered, signed by Magistrate Judge Ann Y. Shields. Let's take a look at one of the motions filed by the media who have made the argument, and the correct argument, that under the First Amendment, this information should not be kept secret at all. The media and the public have an absolute right to know who is paying this $500,000 bond for George Santos. You know, George Santos would otherwise have been kept in custody if this bond was not provided by these individuals. So who has this vested financial interest in the underlying criminal conduct of George Santos? Let's take a look, for example, at the letter by the New York Times. The New York Times letter motion says the following. And in these New York courthouses, they let you file these letter motions. That's why it's in this format. Dear Judge Siebert, I write on behalf of the New York Times to respectfully seek an order releasing unredacted versions of judicial records identifying the bail suretors, the surety records, in the above referenced case. The Times also respectfully requests that the court docket any sealed proceedings that occurred in this case and make public a transcript of those proceedings, the sealed bond proceedings. Under both the federal and common law and the First Amendment, the surety records and sealed public bond proceedings are judicial records that are properly open to the public, and then it cites a number of case law relating to the public's right to information like this. And so, number one, the New York Times is asking for the identity of the individuals who provided this surety bond. Number two, the New York Times is saying if there were hearings that took place, and we believe there were hearings that took place where the suretors spoke with the court and were provided the terms of the bond and made certain representations, all of that was transcribed by a court reporter. Make all of that public as well. The public has an absolute right to know everything that was said there. The letter goes on to explain how the information here relates to the prosecution of the United States Representative George Santos. By the way, just how embarrassing is it that he's still a member of Congress? On May 9th, 2023, a grand jury indicted George Santos on multiple federal crimes. Prosecutors allege that Santos engaged in three criminal schemes. The first, to divert political campaign donations to pay for personal expenses and luxuries. The second, to fraudulently claim unemployment benefits. And the third, to make false financial disclosures to Congress. The prosecution follows months of reporting on allegations that Representative Santos extensively fabricated his personal and professional history and engaged in potentially unlawful charitable business and fundraising schemes. At Representative Santos' initial appearance on May 10th, 2023, Magistrate Judge Ann Y. Shields set his conditions of release. See the order setting conditions of release and appearance bond. At that hearing, which Times reporters attended, the government stated that Representative Santos's release was based on a $500,000 unsecured bond co-signed by 3 suretors. Transcript of May 10th, 2023 from the arraignment. The suretors' identities were not disclosed and apparently remain under seal. It is our understanding that the court also held at least one subsequent hearing with these suretors. However, it appears these bond proceedings were not open to the public, and no record of the hearing appears in the docket. Both the federal common law and First Amendment endow the public with a presumptive right of access to judicial proceedings and records, including to bond proceedings. While that right is not absolute, parties seeking sealing face a particularly heavy burden, whereas here disclosure would not prejudice the investigation or prosecution. The information serves public oversight, and there is a substantial public interest in the prosecution. For the reasons set out below, the Times respectfully requests that the court unseal the surety records, docket any sealed bond proceedings, and make public a transcript of any sealed bond proceeding. And when they say docket any sealed bond proceeding, meaning make those available on the public docket so we all know what took place. George Santos obviously does not want these names released. This is what George Santos stated on May 10th following his criminal indictment. This was right outside the courthouse in the Eastern District of New York. Play this clip.
Appreciate you guys. I appreciate you guys. Here's what we'll do. I will, guys. I will. You see, that is information you'll never get because that is the media's. Your intention is to go harass them and make their life miserable. You're not getting that. All right.
And ultimately, I don't think the Department of Justice is going to oppose this request. Frankly, I was a bit surprised that the names of these suretors who co-signed the $500,000 unsecured bond, that they were kept unsealed in the first place. I would have thought that was something the Department of Justice would oppose. There may be a strategic reason why they didn't oppose it, or just figured the media was going to file the motion, but I would be surprised if the Department of Justice filed an opposition. I think we will see George Santos try to file an opposition, but frankly, what could his opposition actually state? But the law is on the side of the media. The law is on the side of the First Amendment. In this motion, the New York Times points out that there is a strong presumption of access to surety records generally, and it talks about how the public has a right to know who is paying for, especially in this case where we're dealing with someone who's a member of the House of Representatives, who is paying these records. These are usually public records as well. The fact that someone is posting a bond is not something that's traditionally kept secret. There is no countervailing reason to this presumption that it should be public. It's not interfering with the criminal investigation in any way. It's not going to cause any particular problems with the prosecution or reveal any information that may otherwise be classified or that should otherwise be kept confidential. Quite the contrary, these are precisely the type of records that should be made public. And not only should these records be made public, but all of the sealed bond proceedings should be made public as well. These are typically hearings that take place in public view. There should be no reason why it's not made public. And there is especially an overwhelming public interest here where George Santos has a history of engaging in lies to the public. That public transparency and sunlight here is critical. The conclusion of this letter brief by the New York Times states, for all of the foregoing reasons, the Times respectfully requests that the surety records and sealed proceedings be made public, or alternatively, that the government and Representative Santos be required to demonstrate why the record should remain under seal. If they seek to do so, the Times respectfully requests an opportunity to reply and otherwise be heard. We thank the court in consideration of this matter. Following that letter brief sent by the New York Times and other media groups, the court issued that order requiring that by Friday, June 2nd, George Santos and the government respond regarding their positions. We'll see what the government says. I don't think the government's going to say they care one way or the other. Santos will oppose it, but on what grounds does he have to actually oppose it other than he doesn't want it to be released? But of course, we'll keep you posted here on the MeidasTouch Network when we learn more. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your incredible support. Check us out at patreon.com/MeidasTouch, and wherever you get audio podcasts, subscribe to the MeidasTouch podcast. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.